All right, welcome to wills. We're going to be first looking at whether or not a will is valid by analyzing its requirements. There are statutory requirements necessary in order to make a valid will, and they vary slightly among jurisdictions. Most of what we talk about in this module is the attested will. That is one that is witnessed. There is also something called a holographic will that is typically in the handwriting of the testator. Some portion must be in the handwriting of the testator and not necessarily witnessed. The handwriting of the testator substitutes the witnessing requirement. There are separate holographic will statutes. There's also something called a joint will in which two people make one will, which is not really common and frowned upon, but we will look at that a little bit. Remember the Gruen case, the birthday card was not a will. Why is that? The requirements for a valid will include capacity, both legal and testamentary. Testamentary intent, you've got to intend the document to be your will, and formalities. This chapter, we deal primarily with the formalities. The capacity and intent issue is dealt with in Chapter 8 on will caveats. All right, so in terms of the statutory formalities, we are basically looking for a writing, something that is signed by the testator or a proxy and witnessed. Take a look at the Maryland statute 4-102, writing signed by the testator or proxy, attested and signed by two or more. The term Maryland use is credible witness. Not sure exactly what a credible witness is, but we will discuss that. In the Morris v. West case that you've read, their Texas formality statute is a little bit different. Attested by two or more credible witnesses, they include that the witnesses only have to be 14 years of age. So we could have wills valid in one jurisdiction and not in the other. Signed by the testator. What exactly does signing mean? Remember, signing is any mark made with the intent to authenticate, so an X. In terms of having someone else sign for the testator, what's referred to as a proxy, the key is that the proxy and the testator must be in the physical presence of each other. So a telephone call to the attorney saying, please sign my will, I'm on the way to the airport, will not be sufficient. All right, how strict are these formality requirements? Well, let's call it strict compliance. Maryland says they must be literally complied with. No shortcuts. In fact, in the Morris v. West case, we see that exactly as the problem. The UPC, however, thinks, oh, well, that might be a little overkill. If we could show that the will was intended to be a will, we'll kind of overlook some of these minor formality flaws. And this is what's called substantial compliance or harmless error. As long as we can show by clear and convincing evidence that the decedent intended the document to constitute a will, we sort of overlook some of these minor formality flaws. And that is one thing that we should look at and think about from the Morris v. West case. Do you think that Morris v. West would have been found to have been a valid will using the substantial compliance doctrine? All right. Keeping in mind attestation, what is it? It's the act of the witnesses seeing the event. It is not a requirement, and sometimes it's a decoy in terms of these bar exam questions. It is not a requirement. It creates a presumption of due execution. Take a look at the samples. Who can be a witness? Well, no problem with the attorney being a witness. Most importantly, in Maryland and the UPC, We do not have a disinterested witness rule, so a beneficiary under the will can also be a witness. No problem with the UPC as well. Keep in mind that the UPC statute is a little less strict than Maryland. They require the individuals to be signed within a reasonable time of the signing or acknowledgement, or it could be acknowledged before a notary public. Now, keep in mind the UPC is just a model statute. Many jurisdictions borrow pieces of it, but not adopt it in its entirety. Substantial compliance is a big one. We need to think about whether or not first you analyze it in terms of strict or literal compliance, and then secondly, we look at substantial compliance. What's a self-proving affidavit? A self-proving affidavit is something separate and apart from the will itself. It is a separate set of signatures, a separate document witnessed and notarized. In some jurisdictions, it creates a presumption of due execution. It does not add any value in Maryland. We'll take a look at the matter of will of Rainey and see how the self-proving affidavit, along with substantial compliance, was used to validate an otherwise invalid will. Who can be a witness? This is a bar exam favorite. If you see a situation in which the person who is benefiting under the will is also serving as a witness, it should raise some concern. As I mentioned, Maryland and the UPC will not invalidate it based on that requirement, but jurisdictions like New York could potentially invalidate the will, and you can see that this happens to be a bar exam favorite and touched on. Anytime you see someone who is witnessing and benefiting raise this issue as to whether or not the will might be invalid. Let's take a look at a problem with respect to the New York statute. We've got the niece and daughter as witnessing, and there is a big general bequest to the niece of $50,000. Because the niece is both beneficiary of the $50,000 bequest and witness, what the New York statute would do would be invalidate that general bequest, and the balance of the will would stand. All right, now we've talked about different jurisdictions having different statutes. And I want you to know that the first place in analyzing whether or not a will is valid is the statute of the jurisdiction in which the decedent is domiciled as of date of death. If the will is invalid under the domicile at date of death jurisdiction, we have a separate statute called a saving statute or choice of law that allows the will to be valid as long as it was valid where executed. Okay, so you're going to first look at domicile, then think about the saving statutes, or at least raise that issue to the extent it's invalid in a jurisdiction of domicile. Maryland has that statute as well. And take a look at the problems. The Pennsylvania will, this happened in Baltimore City, does not have a witness requirement. You can notarize the will instead there. They adopted that piece of the UPC, and they then died a resident of Maryland, never were a resident of Pennsylvania. It doesn't require you be a resident of Pennsylvania, but does require that that is where the document was executed, which means that you would have to show that and prove that. We'll take a look at the Morris v. West case. Make sure you understand the estate plan and what is the formality flaw that is at issue there. We had a presence requirement. The secretaries were down the hall. The testator was in the conference room. So was that presence requirement satisfied? What is presence? We've got strict presence and conscious presence. Most jurisdictions would just recognize conscious presence. You could, with a slight alteration, see what was being going on, see the testator signing. Castruccio is a big Maryland case that was litigated in the courts for many years. I want you to make sure you understand that. It does a very good job at laying out the history of the formalities and making a discussion there. As I mentioned, a holographic will, Maryland has a separate statute that you want to take a look at. Very limited situation in which a holographic will would be honored in Maryland. UPC, much broader. Anytime you see a document in the handwriting of the testator that is unwitnessed, it should be analyzed as whether or not it may satisfy a holographic will statute. Larry King was probably the last famous person to die with a holographic will. So it's not about whether or not you can afford legal services. He died with a holographic will, and his estate resulted in years of litigation. A joint will, again, is one that is one will and two persons. On the death of the first, the survivor still has a will, but the beneficiaries under the joint will become contract beneficiaries. It's not very well favored by the court because it creates all kinds of administrative problems.